delivery and acceptance of the deed. From the Barbri outline on real property, page 111. Delivery in general. A deed is not effective to transfer an interest in realty unless it has been delivered. Physical transfer of a deed is not necessary for valid delivery, nor does physical transfer alone establish delivery, although it might raise a presumption thereof. Rather, delivery refers to the grantor's intent. It is satisfied by words or conduct, evidencing the grantor's intention that the deed have some present operative effect. For example, the title pass immediately and irrevocably, even though the right of possession may be postponed until some future time. Examples: 1. O drafts an instrument conveying Blackacre to A and hands the instrument to A for safekeeping. Although handed to the named grantee, this is not a valid delivery. There is no evidence that O intended the instrument to have any present operative effect. 2. O drafts the instrument conveying Blackacre to A. O attempts to give the instrument to A personally, but is unable to find A. Nevertheless, O quits possession of Blackacre and thereafter treats A as the owner thereof. Nearly all courts would hold that there has been a sufficient delivery. Under some circumstances, for example, when a third party is involved, conditional delivery is permissible. This type of delivery becomes effective only upon the occurrence of a condition, but the transfer then relates back to the time of the conditional delivery. The grantor has only limited rights to revoke prior to the occurrence of the condition. See further discussion of conditional deliveries. A. Manual delivery. The delivery requirement will be satisfied where the grantor physically or manually delivers the deed to the grantee. Manual delivery may be accomplished by means of the mail, by the grantor's agent or messenger, or by physical transfer by the grantor's attorney in the grantor's presence. B. Presumptions relating to delivery. As a matter of theory, a deed may be delivered by words without an act of physical transfer. Delivery is presumed if the deed is Remnant 1 handed to the grantee, or Remnant 2 acknowledged by the grantor before a notary and recorded, unless there is some clear expression of intent that the grantor envisioned the passage of title to the grantee without physical delivery. The continued possession of the deed by the grantor raises a presumption of non-delivery and therefore no passage of title. Conversely, possession by a grantee of a properly executed deed raises a presumption that the delivery requirement has been satisfied. Note, however, that the presumptions involved are rebutable. C. Delivery cannot be cancelled. Title passes to the grantee upon effective delivery. Therefore, returning the deed to the grantor has no effect. It constitutes neither cancellation nor reconveyance. Parole evidence admissible to prove grantor's intent. The majority rule is that any type of parole evidence, including conduct or statements made by the grantor before or after the alleged delivery, is admissible to prove her intent. 2. Not admissible to show delivery to grantee was conditional. If a deed is unconditional on its face and is given directly to the grantee, in most jurisdictions, parole evidence is not admissible to show that delivery was subject to a condition. Example: O delivers an absolute deed of Blackacre to A, but tells A that the deed is effective only if A pays off the encumbrance on the property, or only if O does not return from the hospital. Under the above rule, even if A never pays off the encumbrance, or if O returns from the hospital, A is the owner of Blackacre and O cannot claim there was no valid delivery. Rationale: the rule is designed to avoid unsettling of land titles which appear to be in the grantee's name, and to protect both innocent third parties and grantees from testimony fabricated by grantors. Third, admissible to show no delivery intended. So we're talking about parole evidence. It's admissible to prove the grantor's intent. It's not admissible to show delivery to grantee was conditional, but it is admissible to show no delivery intended. But while parole evidence is not admitted to prove that a delivery was subject to an oral condition, parole evidence is admissible to prove that the grantor did not intend the deed to have any present effect at all. For example, O tells A, I want you to have Blackacre when I die, and I'm giving you this deed to Blackacre so that you can have it at that time. Most courts would hold that O's statements are admissible, and that despite the unconditional nature of the deed itself, they show that O did not intend the deed to have any present effect. A, deed intended as mortgage, under the admissibility to show no delivery was intended. B, the transfer of the deed to a bona fide purchaser is admissible to show no delivery was intended, and within which estoppel in favor of an innocent purchaser and a comment ensue. So admissibility to show no delivery intended when the deed is intended as a mortgage. Parole evidence is always admissible to show that a deed, absolute on its face, was intended by the parties to be a mortgage. For example, there was no intent to convey title outright. B, the transfer of deed to a bona fide purchaser is admissible to show no delivery was intended. So, suppose O gives A a deed for examination by A's attorney. Deed not intended to be effective at this point. A wrongfully records it and sells to B, a bona fide purchaser. On these facts, O would prevail against B unless stopped to assert lack of delivery. See below. In other words, absent estoppel, a subsequent bona fide purchaser is not protected. If there was no delivery, the bona fide purchaser's grantor had no power to convey. 1. Estoppel in favor of an innocent purchaser. Even though the grantor is allowed to show that no delivery at all was intended as against the grantee, he often is estopped to assert lack of delivery against an innocent purchaser. For example, O gives A a deed but does not intend the deed to be presently effective. A shows the deed to an innocent purchaser B who buys the land in reliance thereon. B will prevail in litigation with O, the original grantor, if it appears that O negligently permitted A to have possession of the deed. Rationale: as between two innocent parties, the one who contributed most directly to the loss must bear the burden of it, and in many cases O must be deemed responsible for entrusting A with the deed absolute on its face. The same result occurs where the grantee records the deed and an innocent purchaser relies on the recordation. Comment: obviously, the above rules give the courts flexibility to define either delivery or non-delivery in many situations. It is also evident that there exists a theoretical inconsistency in admitting parole evidence to show that no delivery was intended, but not to show that delivery was conditional. This inconsistency has been criticized by numerous commentators. So, there's several more rules here. Retention of interest by grantor or conditional delivery. Problems arise when the grantor attempts to retain an interest in the property, for example, a life estate, or when he attempts to make the passage of title dependent upon the happening of a condition or event other than delivery. A. No delivery. Title does not pass. If the grantor executes a deed but fails to deliver it during his lifetime, no conveyance of title takes place. Without adequate delivery, the title does not pass to the intended grantee. 2. No recording. Title passes. If the grantor executes and delivers a deed but fails to have it recorded, title passes. Therefore, an agreement between the grantor and grantee to the effect that the deed will not be recorded until some event takes place in the future does not affect the passage of title. Excuse me. C. Express condition of death of grantor creates future interest. When a deed, otherwise properly executed and delivered, contains an express provision that the title will not pass until the grantor's death, the effect is to create a present possessory life estate in the grantor and a future estate in the grantee. Note, however, that this result follows only when the deed expressly contains such a provision. D. Conditions not contained in deed. If a deed is absolute on its face, but is delivered to the grantee with an oral condition, for example, title is not to pass until I return from the Orient, the traditional view was that the condition dropped out and delivery became absolute. A growing minority of cases enforces the condition. Where the condition is the grantor's death, the deed is usually held testamentary and therefore void unless executed with testamentary formalities. E. Test. Relinquishment of control. To make an effective delivery, the grantor must relinquish absolute and unconditional control. Third, where grantor gives deed to third party. So, when we're talking about delivery and acceptance, and delivery in general was one. 2 was then retention of interest by grantor or conditional delivery, and third now is where the grantor gives deed to a third party. So, in this situation, the rules are quite different. Conditional delivery is permissible versus when retention of interest by the grantor occurs or a conditional delivery occurs. Where the grantor gives deed to a third party, conditional delivery is permissible. Situations should be distinguished. Romanet 1, where the grantor gives the deed to a third party, there being no conditions appended. And Romanet 2, where the grantor, in a commercial context, gives such a deed to a third party, there being conditions appended. And Romanet 3, where the situation is the same as in Romanet 2, but the transaction is donative. A. Transfers to third party with no conditions. Is that Romanet 1? If O, the grantor, gives B a deed naming A as grantee and instructs B to give the deed to A, has the delivery occurred? Most courts say yes, but O indicated an intent to make the deed presently operative. A has a right to the deed and O should not be able to get it back. However, if O told B to retain the deed and give it to A upon O's later instructions, no delivery would have occurred. When there are no specific instructions regarding delivery, the question is one of O's intent. If B is A's attorney, delivery seems clear, but if B is O's attorney, a high court might infer that B was merely O's agent and that O thus retained the power to recall the deed. A few courts hold that B is to be treated as O's agent in all circumstances, even if O manifests a clear intention of present effectiveness and consequently no delivery occurs. B. Transfer to third party with conditions. Commercial transaction. Suppose that O gives B a deed naming A as grantee and tells B to transfer the deed to A when A has paid $5,000 on O's account on or before September 1. This is the true escrow situation, the true conditional delivery. Under the circumstances outlined below, a valid conditional delivery has occurred. The deed has a present operative effect in that title will transfer automatically upon the occurrence of the condition. O will retain the title only if the condition does not occur. Parole evidence admissible to show conditions. Even though a deed is unconditional, the general rule is that parole evidence is admissible to show the conditions and terms upon which a deed was deposited with the escrow. This is contrary to the rule excluding parole evidence where transfer is directly to the grantee. If the escrow custodian has violated parole conditions, there will be no valid delivery once the condition occurs. Whether parole or not, title automatically vests in the grantee, and the escrow holds the deed as the grantee's agent. And second, under the transfer to a third party with conditions in a commercial transaction, is the grantor's right to recover the deed. A is a majority view that the grantor can only recover if there was no written contract. Under the majority view, if the grantor seeks to recover the deed prior to the occurrence of the condition, the grantee can object only if there is an enforceable written contract to convey. On the other hand, once the condition occurs, title passes even in the absence of an enforceable contract. 1. Under this majority view, the requirement of a written contract is based on the statute of frauds consideration that oral contracts to convey realty should not become enforceable simply because the deed has been deposited with a third party. Ordinarily, this is 2, the contract to convey will be a buy-sell land contract. However, written escrow instructions are often a sufficient memorandum of the contract to satisfy the statute of frauds. B. Minority view, no right to recover. A strong minority prohibits revocation even in the absence of an enforceable underlying contract. Deposit of the deed with the third party on stated conditions is seen to obviate most possibilities of fraud. Third is the breach of escrow conditions. Title does not pass. When the grantee wrongfully acquires the deed from the escrow holder prior to the performance of the conditions of the escrow, title does not pass. Therefore, even though the grantee is in possession of the deed, she cannot convey any interest in the land to a subsequent transferee, even a bona fide purchaser. Estoppel cases. A. A few cases have held that where the escrow holder was chosen by the grantor is bound by the escrow holder's acts and is estopped to deny a valid delivery of passage of the title to the grantee. Thus, an innocent purchaser, bona fide purchaser from the grantee, may acquire good title. An important factor is whether the grantor has allowed the grantee to take possession of the property prior to completion of the conditions of the escrow. If the grantor has remained in possession, the purchaser may be held to have notice of the grantor's interest and cannot be a bona fide purchaser. Fourth, the relation back doctrine. In an escrow transaction, title does not pass to the grantee until performance of the named conditions. However, where justice requires, the title of the grantee will relate back to the time of the deposit of the deed in escrow. Generally, the relation back doctrine will apply only if 1, 2, and 3. 1. The grantor dies. Doctrine applied to avoid the rule that that title must pass before death if instrument is not a will. And ruminant 2. The grantor becomes incompetent. In the doctrine applied to avoid the rule that an incompetent cannot convey title. Or ruminant 3. A creditor of the grantor who is not a bona fide purchaser or mortgagee attaches the grantor's title. Doctrine applied to cut off the creditor's claim. I don't like how there's so many parentheses because that sounds really awfully choppy. So the relate back doctrine, title does not pass to the grantee until the performance of named conditions. But where justice requires, the title of the grantee will relate back to the time of the deposit of the deed in the escrow. And this will apply if the creditor dies, the grantor dies, the grantor becomes incompetent, or a creditor attaches the grantor's title. So that's how it reads without the parentheses. But when a grantor dies, the doctrine is applied to avoid the rule that title must pass before death if the instrument is not a will. And what that means is the deed may be transferred unless it's a will that is the instrument of the grant. So if the grantor becomes incompetent, The relate back doctrine. Okay, I see. Will relate back to the time when the grantor was competent and gave the deed, put the deed in escrow. Get it? And then so for the creditor, attaching the grantor's title, the relate back doctrine will cut off the creditor's claim because it will relate back to the time of the deposit. What is it? Well, the doctrine, the relation back doctrine will cut off the creditor's claim because the deed was already put in escrow, and that's what's effective here. Now there's an A and a B and a C under the relate back doctrine. So for A, this is not applied if the intervening party is a bona fide purchaser or mortgagee. B, it is not applied in favor of escrow grantee with knowledge. And C, the transfer to a third party with conditions, also known as donative transactions. Appear to have something to do with the grantor's death. So, the relation back doctrine is not applied where the intervening third party is a bona fide purchaser or mortgagee. However, if the sales contract is recorded, there can be no intervening bona fide purchaser because its recordation gives constructive notice. That is A under the relation back doctrine. B, not applied in favor of escrow grantee with knowledge. So the relation back doctrine will not be applied in favor of an escrow grantee who at the time she performs the terms and conditions of the escrow has actual or constructive knowledge of prior equities of other persons, for example, that the grantor conveyed to another. But if the escrow grantee has performed part of the conditions when she acquires such knowledge, she will be protected against all but bona fide purchasers or mortgagees. And C, transfer to third party with conditions and donative transactions. If the grantor gives a deed to a third party with instructions to turn it over to the named donee only when certain conditions occur, is there a valid delivery, or can the grantor change her mind and demand the deed back before the conditions occur? So there's 1, the condition unrelated to the grantor's death, when O gives to B a deed naming A as grantee and instructs B to give it to A when A marries. For example, no true escrow will exist unless there is an underlying contract of sale, which is extremely unlikely in a donative transaction such as this. Hence, O can retrieve the deed from B upon request. Nevertheless, if O does not do so and B actually delivers the deed to A after the condition is satisfied, the delivery will be effective to convey title to A as of that date. Number 2, where the condition is the grantor's death. When O executes the deed to A and hands the deed to B with instructions to give it to A upon the death of O, most courts hold that the grantor cannot get her deed back because her intent was to presently convey a future interest to the grantee, either a remainder with a life estate reserved in the grantor or an executory interest. Note that this analysis also makes the gift inter vivos, not testamentary, and thus not in conflict with the statute of wills. Caution: in dealing with death cases, make sure that it was the grantor's intent that the deed be operative immediately to convey a future interest. And A, within that section, is a limitation that no delivery if conditioned on survival. So when O instructions to B are to deliver the deed to A only if A survives O, it is generally held that there is no valid delivery because it was O's intent to retain title and possession until her death. So, we're going to go into acceptance, part 4, in a moment.